Hola, soy la abogada Brittany James y estoy aquí hoy para contestar todas sus preguntas en relación de inmigración. Si tiene algunas preguntas sobre inmigración, puede escribir sus preguntas aquí en los comentarios abajo en TikTok o Facebook y puedo contestar sus preguntas ahorita en vivo. Recuerda que como siempre en ese tipo de situación solamente puedo dar información en general y contestar sus preguntas en una manera general. No debe tomar ninguna de esa información como una opinión legal sobre qué usted debe hacer en su caso, porque para dar una opinión legal tenemos que hablar mucho más para explorar todas sus opciones y tengo que tener más detalles de usted que realmente no puedo conseguir en ese tipo de situación cuando estoy hablando en vivo. So, si quiere una opinión legal, debe llamarnos para programar una consulta conmigo. Nuestro número de teléfono es 772-539-8400. Pero si tiene algunas preguntas, puede escribir sus preguntas aquí en inglés o en español, en cualquier de los dos idiomas, y puedo contestar sus preguntas ahorita. También, si no tiene una pregunta específica, pero si hay algún tema relacionado con inmigración que quiere escuchar más información, puede poner eso en los comentarios también. So puedo hablar sobre cosas que ustedes quieren escuchar. Ok, so, mientras que estoy esperando por unas preguntas, el tema que quiero hablar hoy es sobre diferentes maneras que puede probar que tiene una relación real con su pareja, con su esposo o esposa. Porque inmigración siempre cuando está aplicando basado en un matrimonio, si es basado en una petición de su esposo o si está aplicando basado en abuso, tiene que probar que tenía una relación real. También si está aplicando como un viudo, si su esposo falleció, también tiene que probar esos tipos de cosas. Y a veces es más difícil si el matrimonio era muy corto, o también si era víctima de algún tipo de abuso, a veces no tiene acceso a ciertos documentos. So esas son cosas importantes de saber, cuáles tipos de pruebas puede usar. Los normales primero son como copias de su cuenta de banco, el contrato de renta de la casa, seguranza de vida, seguranza de salud, prueba que eres dueño de propiedad juntos, fotos, pero también otros tipos de cosas que pueden ayudar, por ejemplo, son um, el, sus comentarios en sus redes sociales, ¿sí? Como Facebook o Instagram, esos tipos de cosas puede imprimir copias de todo eso para probar que ustedes estuvieron escribiendo cosas sobre cada uno o que estuve poniendo fotos y eso es muy bueno porque va a tener la fecha. So, eso es muy, muy buena prueba de su relación, aparte de solamente fotos normales. Okay. Y por las personas que están viniendo ahorita, si tienen preguntas, por favor, escribe sus preguntas aquí y puedo contestar sus preguntas ahorita. Como estuve explicando antes, no debe tomar esa información sobre como una opinión legal sobre su caso. Um, por una opinión legal tiene que llamarnos para programar una consulta conmigo, pero puede poner sus preguntas aquí o también si hay algún tema relacionado con inmigración que quiere escuchar más información, puede poner eso en los comentarios también, ¿ok? So, otros tipos de cosas que puede usar para probar su relación con su esposo o su pareja son, por ejemplo, um, cualquier documento que demuestre que estuve recibiendo correo en la misma dirección, no tiene que siempre ser juntos, pero también cosas separadas. Una de las cosas que siempre estoy diciendo a mis clientes es que por la manera que casi todos usan correo electrónico ahorita, probablemente si buscan su correo electrónico por su dirección, van a encontrar muchos diferentes documentos que tienen su dirección y su nombre, para probar que estuve viviendo en esa dirección. Um, Ok, David luego está preguntando cuánto me cuesta para meter una aplicación para un permiso de trabajo. So, David, eso depende en qué tipo de caso es. ¿ok? Hay muchos diferentes tipos de casos de permiso de trabajo, porque el permiso de trabajo nunca es solamente una cosa. El permiso de trabajo siempre está basado en algún tipo de casos. O por ejemplo, si califica por el permiso de trabajo porque tiene un caso pendiente con el juez, un caso de asilo o un caso de cancelación de deportación, también puede aplicar por un permiso de trabajo junto con una aplicación de la residencia. O si está aplicando por la visa T como víctima de tráfico en labor o la visa U como víctima de un crimen. So, el permiso de trabajo nunca es solo una cosa. Lo que cobra inmigración normalmente es 400 días. A veces depende del caso 495 y hay unos casos que no tiene que pagar. Pero por los honorarios del abogado todo depende en qué tipo de caso es. Sí, eso realmente no es una pregunta que puedo contestar sin saber más de su situación. Ok, si quiere una consulta puede llamarnos, podemos revisar toda su situación para ver cuáles opciones tiene. Okay, y nuestro número de teléfono para programar una consulta es 772-539-8400. Ok, lo siento, yo sé que eso no es una respuesta 100% a su pregunta, pero realmente eso es una pregunta que no puedo contestar sin hablar más con usted para ver cuáles opciones tiene. Um, ok, tengo otra pregunta aquí en TikTok, pero está en inglés, so voy a contestar eso en inglés primero. The question that I just got on TikTok, my dad is waiting for his perdón. He had his prints taken. Does he have to go out to Ciudad Juarez? So if your dad is here and he has filed for the I-601A application, the perdón provisional, this type of application is only used when someone is going to go to an interview abroad. So if that's what he's filed, I don't know if he has an attorney or not, but if that's what he's filed, then that's the path that he's on. Whether he has any options to apply here or not would depend on his situation. So I would need to know a lot more about him to say whether he's going to have to leave or not. Also, I couldn't say based on this whether the process that he's going on is the best option for him and whether he would have any issues. So I wish I could answer your question a little bit better, but it would really depend on his case. But in general, if he's here and he's applying for the perdón, then the intention would be to leave the country for his interview in Juarez. I will say it's taking a very long time right now for Juarez, and also for the waivers, the provisional waivers, we've seen them taking about 1.5 to 2 years to be approved. And then after that, once the National Visa Center has everything that they need for the interview, it could possibly be another year or two before they even schedule him for an interview. So he could still be, I would say, maybe between 2.5 to 4 years away from getting to the point of having that interview in Ciudad Juarez. So if he hasn't already, I would highly recommend that he consults with an attorney just to see, is this still his best option, or is there another option available to him where he could possibly adjust his status faster, or where he could file here, okay? Because depending on his situation, he may be able to. All right, so Maria Portillo is asking, how long is the wait for a U visa? So this is a very tricky question right now. So they are currently approving U visas that were filed around the end of 2015, beginning of 2016. So for those people, it took them about between 5 and 6 years, right? But for people that are applying now, my best estimate is that it could take 14 or 15 years, possibly more. And the reason for that is because immigration can only approve 10,000 U visas each year. And as of the last time that I checked, which immigration publishes all of this information on their website, they had over 165,000 applications being processed that were pending. So of course, I'm sure some of those may be denied for whatever reason. Some of those people may also obtain another status even before their U visa is processed, so the cases will be closed out. But assuming that the majority of those go through, I mean, even if all of them are approved, then it would be over 16 years for people that are applying today. I know that not all of them would be approved, but I would say probably a significant number of them would be approved. So I would say the wait for people applying now is going to be at least 10 years, probably more like 12 or 13 years, unless there's some type of change to the law between now and then. Congress is the only one that has the ability to change the caps on the visas. So if Congress takes some type of action and decides to raise the visa cap for the U visa and allow more approvals every year, then obviously that could make a big difference. But as of right now, yes, it could be a very long time. Now, I do think that there are a lot of benefits to applying, even though it takes so long. First, in Florida, for people that apply for a U visa, while the case is pending with just the receipt notices, you can obtain a driver's license, which I know some states it's much easier to obtain a driver's license, but in Florida, you have to show certain requirements with immigration to be able to qualify for a driver's license. So that is a very, very big deal. And the way that the law is written right now, the driver's license can be extended every year until there's a decision on the U visa application. The other benefit is once immigration reviews the application, they can give deferred action and protection from deportation. In the past, this was taking several years, but with the new process that they came out this year called the bona fide determination, we're hoping that that will be much faster. We still don't know for people that are applying today, but at least there is a potential to get a work authorization much faster than before. Also, although this isn't specifically written in the law, I do think that having a pending U visa, assuming that it's a bona fide application, it does provide a little bit more protection from immigration. It doesn't mean that you're completely protected, that immigration is not allowed to deport you, because they can deport people with a pending U visa application. But in my experience, if you're not committing any serious crimes and you're not doing anything else wrong, in many cases, immigration will let someone stay when they have a pending U visa until there's a decision. That doesn't mean that it's always going to be like that, but I've seen that in many cases, even people with removal orders that are checking in with ICE. In most cases, if they see that they have a pending U visa, then they will hold off on the removal to wait for a decision. Okay, so I hope that that helps. I know that that was a very long answer to your short question of how long is the wait for a U visa, but I think it's important to explain all of that so that you understand how everything works better. Okay, if anyone else has any questions, you can write them in English or Spanish, either one, and I can answer them. Si alguien más tiene preguntas, puede escribir sus preguntas en inglés o en español, en cualquiera de los dos idiomas. Probablemente solo voy a estar aquí por unos minutos más, no mucho más tiempo. So si tiene preguntas, debe escribirlos ahorita. Y como estuve explicando antes, en ese tipo de situación solo puedo dar información en general. No puedo dar una opinión legal sobre qué debe hacer en su caso. Por eso tiene que programar una consulta conmigo donde podemos revisar todos los detalles de su situación. Okay. Y nuestro número de teléfono para programar la consulta es 772-539-8400. Ok, tengo otra pregunta en TikTok, pero está en inglés, so voy a contestar en inglés primero. The question that I just got on TikTok is: married with undocumented, 2 children, one with special needs. He left and re-entered and was detained 3rd time. Now, as far as whether he would be able to do something, I would need to know a lot more. And just saying that he was detained at the border doesn't tell me everything. I mean, I would need to know also, was he detained and actually issued a deportation order? Was he just turned around and given a voluntary return? So first, I would need to know a lot more to say what we could do for him. But assuming the worst, assuming that he has a deportation order, okay, there are still sometimes some options. So some of the options that I would usually be looking at for someone with a deportation order or with a permanent bar would be, first, have they ever been a victim of any type of crime in the United States? Also, have they ever been a victim of labor trafficking or sex trafficking? I have been very surprised after learning what types of questions to ask and how it works. I've been very surprised at how many clients have been victims of labor trafficking, and most of them are not aware that what happened to them was labor trafficking. So that would be something that we would explore in a consultation. I would also want to know if he's ever been subjected to any type of domestic abuse, even if it wasn't physical abuse, emotional or psychological abuse or control. Those are things that sometimes could help someone even if they have been deported before and re-entered. So if you would like to explore that more, you can call me and schedule a consultation. We can go over his whole case and see what we're able to do for him. Okay. Now, another question I got, how many affidavits of support can my application have if I don't make enough to support my husband? So if the application is for your husband, first, if you, regarding your affidavit of support, if you don't have enough income, you can also use assets to qualify. It's a little more complicated when you're using assets. You would basically take the difference of your income and how much you need to qualify. And if you're a U.S. citizen, that would have to be multiplied by 3. And that's the amount of assets that you would need to have. Or if you're a resident, it would be multiplied by 5. So assuming that you don't qualify based on that, also assuming that you don't have any other family members that reside with you whose income could be combined together with yours, because sometimes that could be an option, then in general there could only be one joint sponsor. Now that joint sponsor, if it is, for example, someone that's married, then they could technically apply together, but there would be one as the primary joint sponsor and then a household member. Okay, so there could potentially be more than one person, more than one sponsor, but technically one affidavit of support, and then there could be other family members included in that if that person doesn't earn enough on their own. Okay, and also if your husband happens to have a work authorization already, then his income may be able to count. But of course, if he doesn't, then you would not be able to include his income even if he's working. And you would have to have another sponsor if you don't qualify on your own. Okay, and I have another question here on TikTok. I'm a U.S. resident. If I claim my new wife who has been in the USA with a visa, how long will the wait be? So for legal permanent residents filing for spouses, I'm just going to double check the visa bulletin just to see where they are at. So that category, yes, all across the board, that category is current right now, which means that that there's no wait technically other than the time that it takes for the petition to be processed. So if your spouse is abroad, then first you would have to file the I-130 petition, wait for it to be approved, and then once approved, go through a process of counselor processing to be able to bring them back in. Now, if your spouse is here currently and entered on a visa, if she's still in status, then you could potentially file for an adjustment of status here, as long as she's in status at the time that it's filed. But if she's out of status already, then as a resident, you could not. Okay, if she's out of status, then as a resident, as a spouse of a resident, she would not be eligible to adjust her status here in the U.S. if she's already out of status. In order to do that, you would have to be a U.S. citizen. Okay, so anytime someone entered with a visa, if they overstayed their stay, they could not adjust status in general through a legal permanent resident, only through a U.S. citizen spouse. Okay, so I hope that's helpful for you. And if you would like a consultation, if you'd like to discuss it more, then you can give us a call and we can review everything together, and I can let you know if I see any issues and also what type of fees would be involved for us to help with that process if you wanted assistance. Okay, and our phone number again is 772-539-8400. Okay, I think this is going to be everything for today, but you can always look for when I'm live answering questions and come to ask your questions. So every Wednesday at 5 p.m. Eastern Time, I'm always going to be doing a live video. Other than that, it's almost every day, but just at different periods in the day, depending on when I have a few minutes. And then if anyone would like to schedule a consultation, of course, you can either send us a message on Facebook or you can call our office at 772-539-8400. And I'm going to go ahead and explain that in Spanish also. So eso va a ser todo para hoy, pero Como siempre, si tiene algunas preguntas, puede tratar de mirar por cuando estoy hablando en vivo y puede venir para hacer sus preguntas. Y cada miércoles a las 5 de la tarde Eastern Time, siempre voy a estar haciendo un video en el mismo tiempo, pero los otros días dependen cuando tengo unos minutos para hablar, normalmente en diferentes tiempos, ¿ok? Pero si quiere una consulta conmigo, puede mandarnos un mensaje en Facebook o puede llamarnos al 772-539-8400. Ok, tenga buen día y nos vemos ustedes mañana.